Hello everyone, my name is Scott Aubrey. I am the owner of Aubrey Law. We are an estate planning law firm and I'm so happy to be here with you today. And today I'm going to talk about the limitations if your estate plan only contains a will. But before I get to that, if you have any questions about what I talk about today or any questions about estate planning in general, you can go to estateplanmeeting.com and schedule time to talk with me for free, either in person or on the phone. Again, that website is estateplanmeeting.com. You can go there, you'll see my schedule, pick a time that works best for you, and I'll be more than happy to talk to you for free, either in person or on the phone. So today's topic is the limitations if your estate plan only contains a will. So basically what a will does is it controls what happens after you die. And what it does a couple things. One, it names a personal representative to settle your estate. What that means is they are responsible for transferring your assets to your beneficiaries. They are responsible for paying off your debts. In your will, you also would name a guardian for your minor children. In order for have a valid will, you need to make sure that it's signed by you. It's in the presence of two witnesses that are independent. What they'll do is they will attest that you are of sound mind, you have the legal capacity to create a will, and also so that you have no undue influence. So that's basically what a will does. I mean, those are like very, very specific things. If you only have a will, there's a couple limitations. One being is that a will only comes into effect or only is used after you die. So during your lifetime, your will doesn't do anything for you. It does not come into effect. It really serves no purpose. It's really for what happens after you die. So if you were to become incapacitated, there is no provisions in your will that would be applicable to that situation. So in order for you to plan for incapacity, you need other documents as well. You need a healthcare proxy. You need a power of attorney. You'd also need an advanced medical directive, which will determine what happens if you were in a vegetative state. Do you want a feeding tube? What do you want to happen to yourself? So if you only have a will and you don't have a power of attorney, which deals with someone making financial decisions on your behalf, so basically paying your bills, accessing your accounts. If you don't have a power of attorney, you don't have a healthcare proxy, and you don't have advanced medical directive, then those decisions that those end of life decisions have to be made by someone who's appointed by the court. And if someone wants to make medical decisions on your behalf or a financial decision on your behalf, then the court will have to get involved in order to appoint those people. So if you only have a will, it's very limited. Another drawback of only having a will in your estate is that if you were to want to place restrictions on when your beneficiaries receive money, if you were to have minor children or children who are on the younger side, between the ages of 18 and like 25, and you were concerned about them receiving any amounts of money at that age, then you want to make sure that you have something beyond just a will, because there are no restrictions in a will to do that. So under the rules is that any money that you leave to someone is once they reach the age of 18, they receive that money outright without any restrictions. So if you have concerns about that, or if you want to make sure that that money is used for a certain purpose, then you want to make sure that you have something beyond just a will. And another thing too is that a will only covers certain assets. There are certain assets that are not covered by a will, mainly being certain type of accounts. One would be a life insurance annuity account. Also, a life insurance policy would not be covered by a will, so that you have to make sure that your beneficiary of the policies of the annuities are up to date. Retirement accounts are not covered by your will. Those have beneficiary designations, so you want to make sure that that those are up to date as well. So really, if only you think about your estate plan as being a will, then there's going to be some limitations to that. There's not going to be certain things aren't going to be covered, or you may not think about other things. Any account with a beneficiary designation, things like that. So really, a will is a great place to start with your estate plan, but it's not the only thing that you need. And if you have questions about what more that you need, then you should probably talk with an estate planning attorney. and they can help you, choose what other estate planning documents that you should have in place. As the ones I did mention are definitely something you should have. Even if you don't have a will, you definitely should have the healthcare proxy, the durable power of attorney, and the advanced medical directive. You should have all those things, even if you don't have a will. But if you do have a will, you need those things as well, because as I said before, the will only really comes into effect, or is only really, comes into effect is after your death. So it doesn't really do anything for you during your lifetime. So that's all I have for you today. If you like this video, please hit the like button. If you want to hear more from me about estate planning, you can subscribe to my channel. If you know someone that could benefit from seeing my video, please share this with them. If you have any questions or comment, please leave it in the comment section. I'll be more than happy to answer it for you. And if you have any questions about estate planning, if you want me to review your will, review your current estate plan, you can go to estateplanmeeting.com and schedule a time to talk with me for free, either in person or on the phone. Again, that website is estateplanmeeting.com. Go there. You'll see my schedule. Pick a time that works best for you. I'll be more than happy to help you in any way that I can. Once again, my name is Scott Aubrey. I am the owner of Aubrey Law, and I will talk to you soon.